The High Court has given University College London 4 months to end a dispute with students who want permission to sue the university over disruption to teaching during COVID. Sky correspondent Alice Porter is at the High Court for us and is following this one. Alice, what can you tell us?
Well, look, this is a really important step, not only for students here in London, but also students across the country. Up until now, students who are frustrated with the way the pandemic has impacted their studies were told to complain through their universities or through the Higher Education Ombudsman. But many students wanted to have their day in court and want to have compensation through the court system. And today there's a recognition from a High Court judge that that could well happen. But crucially, a 4-month stay in the proceedings has been implemented, ideally for lawyers representing the students and lawyers representing UCL to come together and make some sort of agreement. But they're very clear, lawyers on behalf of the students, that if an arrangement, an agreement is not made, then this case with UCL may well go to trial, which would set a precedent for universities across the country. Now, I'm joined now by Ryan Dunleavy from Harkers Parker. Now, you're one of the solicitors representing the students. What's your reaction to the decision today? And just explain a little bit more about the significance for UCL and for universities across the country.
We welcome the decision. UCL had applied for a stay unless and until the students had gone through its own internal complaints procedures and also an ombudsman who would then report back to UCL and ask it if it was willing to settle if the ombudsman decided to do so. We said that the ombudsman was an unsatisfactory way of doing it. The ombudsman won't decide on legal issues. It'll decide simply whether the university had acted reasonably. And also, it hasn't dealt with this number of complaints before, ever, and that's just in relation to UCL, never mind the 120,000 students who've come to us. The maximum number of students it's ever dealt with in a year is less than 3,000. So you contrast that with 120,000, it's a completely inadequate system. So we're delighted that the court has said that the students don't have to use that if they don't want to use it, and we'll be recommending that they don't use it, and that they can use instead alternative types of dispute resolution, traditional ones like mediation. And we've been pushing for traditional dispute resolution ever since we wrote our first letter to UCL in April, but it refused to engage with us and said simply we had to go through its complaints procedures. And today's judgment has vindicated our position on that, to say no, they don't have to go through UCL's complaints system, and they don't have to go through an ombudsman, and they can go through traditional methods of alternative dispute resolution. And if that doesn't work out, we will go to trial. So it's a 4-month delay that could actually lead to settlement, which we would invite. We want the students to be paid compensation as soon as possible.
Time may be of the essence for a lot of students, particularly those who, at the moment, we look to Shannon Barnes, a student at UCL who should be graduating this summer. Of course, you've had your examinations caught up in the marking boycott that continues. I mean, what's your reaction to the news today? Because I know you put a complaint in to UCL about the standard in teaching that you received during the pandemic. Talk me through what your experience was like at university and what you were hoping for.
Yeah, so I mean, I'm supposed to graduate in September. I finished my degree now, and for the first two and a half years, it was completely all online. I had lots of chemistry practicals, in-person assessments, laboratory assessments that should have taken place, and I was told to do those at home. I applied through that internal complaints procedure that UCL recommended me to, and I got nowhere. After the first year, I compiled my case together with all the evidence I had, and they told me that regardless of all the things I provided, they thought that the standard of education that they delivered to me and to all the students who had followed the same procedure was up to standard with previous years. And for me, that was a huge knockback, because I felt like I had nowhere else to go, no other options. UCL are telling me no, I don't know what else I can do. And I kind of gave up after that first year. And then when this came about again, I thought, okay, finally, now we're getting somewhere. The judgment today is not, of course, we'd all have liked to get the compensation and get it as soon as we can, and, have UCL and universities across the country recognise that, students didn't get the experience that they should have been given. And for me, these was supposedly the 3 most memorable years of my life and my university education, and I just feel like it's been tarnished with so many things now. And I am happy with today. I'm happy that, now there's going to be this potentially 8-month-long procedure where assessment could be agreed, and alternatively then it will be going to court and, we'll be going to trial eventually. So, yeah, I'm happy. I'm positive. I'm just, keeping our hopes up, and let's just see what happens over the next 4 months.
Well, listen, good luck, and good luck for your graduation. A really interesting picture here at the High Court in terms of this decision made on behalf of UCL students.
Alice, thank you. Alice Porter with the latest there from the High Court.